to bring simplified versions of the law in layman's term. Of course, you can stream us on all WESN Content Capital platforms, including Strictly Legal with Rondell Donowa podcast, and of course our social media platform. Today, of course, we are celebrating the conferment of Senior Counsel on Ms. Haseen Sheikh, Chief Public Defender, as well as her notable achievements and, of course, the interpretation of the law when it comes to indictable proceedings. But before, we have our legal lingo segment where we will dissect legal terms for you, the viewers. So let's go to legal lingo. And our legal word for today is indictment. Now, an indictment is a formal written document which states the criminal charges against an individual. The filing of the document begins proceedings before a judge and jury in the High Court. The indictment outlines the specific charges against the accused, detailing the alleged criminal acts and which legal provisions those acts breach. It serves as a foundation for the prosecution's case, ensuring the defendant is fully informed of the allegation and can prepare a defense. Now let's look at a scenario. In the High Court of Trinidad and Tobago, let's say John Doe, he stood solemnly as the judge reviewed the indictment filed against him. Now the formal document drafted by the Director of Public Prosecutions listed charges of fraud and embezzlement. According to the indictment, John was accused of misappropriating funds from his employer between January and June of the previous year, violating sections of the Theft Act. Now, as the court read the charges aloud, it became clear that the indictment meticulously detailed each alleged criminal act, specifying the exact months or the exact amount stolen and the dates of the offenses. Now, this document marked the beginning of the trial, setting the stage for the prosecutor to present their evidence and for John's legal team to mount a defense against the accusation. So there you have it, indictment. We'll be right back with more.
Every word, every line, every paragraph depicts a real moment in someone's life. A father, a sister, a mother, a brother. We at Newsday are dedicated to you, the people, and through independent, unwavering journalism, strive to always bring your stories to life. Because your stories are more than just words. Newsday, independent and credible.
FanZone, your reliable, authentic supplier, has just gotten better. You can now visit our website www.fanzonett.com for your authentic wear and collectibles. The only place where you can use both your Visa debit and credit cards. Visit our website fanzonett.com to make your purchase today.
And we're back. You're watching Strictly Legal on WESN Content Capital. And before the break, I indicated to you that we have a noble guest, Ms. Haseen Sheikh. And we are going to speak about her legal journey and the transformation of indictable proceedings. So just a bit of about Ms. Sheikh. She assumed the role of Trinidad and Tobago's first Chief Public Defender in March 2020. As department head, she has been an integral part of the reformation of the role of the Defense Counsel in the criminal justice system. With the proclamation of the Administration of Justice Indictable Proceedings Act, the department also now manages all of the legally aided committal proceedings before the High Court. Now, Ms. Sheikh was called to the bar of Trinidad and Tobago in 2008. She was a former National Scholarship winner. She graduated from the University of the West Indies and Hewarding Law School. She completed her Masters of Law in Criminology and Criminal Justice in 2016 from University of London. She has practiced at the Magisterial, High Court and Appellate Court level of Trinidad and Tobago. And recently she has been awarded Silk, meaning she is now Senior Counsel. So I have to call her Senior now. Yes, and I without further ado, and she was part of our set, I think it was approximately almost 3 years ago, and I am pleased to welcome her back as now Senior Counsel, Ms. Hussein Sheikh. How are you?
Good morning. I'm well, thank you.
And congratulations on your appointment, well deserved, and as I was saying to you off air, it inspires other attorneys, other young attorneys within the qualification bracket to achieve the same level of achievement as you have done.
Absolutely.
You know, so once again, congratulations.
Thank you so much.
Yeah, so let's start. How does it feel? How does it feel? Apart from all the media highlights, I mean, it's about you. How does it feel?
How does it feel? I mean, it feels that in a way that, you know, we have a lot of work to do. And I think it's an important acknowledgement of my current role as Chief Public Defender and how much has been done there. And then, of course, in terms of what a senior counsel is supposed to be, we're supposed to be a leader, a mentor. Apart from doing court work and, you know, being able to perform in that regard, I think the most important job or the belief that of what a senior counsel should bring to the table is that ability to lead and mentor. So, you know, I always say that when you get these opportunities, you also get a lot to work with.
Exactly.
So it's not one without the other, unfortunately. But, you know, extremely honored, very grateful. It is a privilege, ultimately, to be able to serve at this level, and I'm happy to do so.
Quite correctly, and of course you trained prior to the Chief Public Defender role. You'd have been involved primarily in criminal practice.
Correct. Primarily in criminal practice. So I started in 2020 in this particular role. So prior to that, from the day that I was called to the bar, I have been defense counsel. So, I mean, in the sense that I did other things apart from criminal law, but criminal law has always been my passion. It's always something that I feel very strongly about. And, you know, I could go on and on about my passion when it comes to these things. But I think it's an important area. It's an important area because this is really one of those areas where you get to serve the underprivileged. And that's a definite necessity in this day and age.
Now, as Chief Public Defender, I know we spoke about it before, but just to refresh persons' memory and, of course, our new listeners and viewers, what is the role of the Chief Public Defender and, of course, your department? And later on, what is the difference between the Chief Public Defender's department and the Legal Aid department?
Certainly, I'm happy to explain that. So, the Public Defender's Department, I suppose I can answer both in one. Sure. The Public Defender's Department is created under the Legal Aid and Advisory Authority. We're a department that exists within Legal Aid. So what our role and function is, essentially, is to provide criminal defense representation to those persons who cannot afford. So persons who qualify for legal aid, they can get a public defender. Now, we still work in tandem with other private attorneys who offer their services to legal aid. So it is not that we do all of it, but we do a significant portion of it. So we are responsible for doing quite a number of matters at the High Court. We do appeals, and, well, we're going to talk about AJIPA a little bit today.
Yes,
and
definitely.
we do a lot of work when it comes to AJIPA as well.
So therefore, in your department, so is it like a hybrid system where you have attorneys, as you said, you have attorneys who are in private practice, work for the Chief Public Defenders on retainer, or is it?
No. So what happens is how legal aid was set up under the Legal Aid and Advice Act. There is the provision for the creation of panels. So when we create these panels, there is one specifically who do criminal work. So you can decide what you want to do. So any private attorney who wishes to sign up for the panel can. So they can choose to do district court work, which is what we previously knew as magisterial work. They can choose to do high court work. You can even choose what type of offenses you want to do. Once you do the work, you are handling it on your own. It'll be assigned to you. You manage your matter. You complete your matter. We only come in at the end to essentially pay fees at that point. So it's not that you're on retainer to us in that concept. It is more that you are handling it separate and apart, but you have agreed as part of your private practice to do legal aid matters. And then the attorneys who work within the Public Defender's Department are employed full-time as defense counsel, and we do work in the High Court.
And how many public defenders are currently in your cadre of
So we currently have 30 attorneys that are employed. We're in the process of recruitment, so we have ongoing recruitment. Our maximum capacity at this time is 38. Of course, there's always a need for more. Unfortunately, there's always a need for more. I feel like I would echo every agency that says, you know, more is always required. But right now, we're at that 30 mark.
Now, in terms of the scope of a public defender and as well, the intent of Parliament or whomever to create this department, has it been working in terms of access to justice?
So the Public Defender's Department had been created essentially to offer those persons who required representation to have a full-time attorney who could do it, because we were primarily dependent on the private bar before, and I was one of those private attorneys. And the reality is we have a small number of attorneys at the private bar who were able to do criminal matters. So at any given time, you're jostling in your schedule to see where you could fit matters in. So has it improved? I think it has. We have completed, I want to say, about close to 350 matters since 2020. We currently have about 2,000 matters that we're managing internally. So these are what our attorneys, our 30 attorneys are managing. And we have also taken on a JIPA. So in terms of how much work we're doing and the ability to actually achieve that goal or that mandate of being able to be in the court day to day in a more consistent manner, I think that is something we're definitely able to do.
And are you all able to, I mean, of course, now juggle multiple matters due to virtual court? I mean, I know that's a
benefit to some extent. So, I mean, I think virtual court, when it comes to CMCs, those case management conferences, I mean, I could be in Tobago, San Fernando, and Port of Spain.
At the same time.
Or at the same time with virtual courts. I mean, that is really a benefit that came out of COVID. I mean, I cannot, the time that it would take to traverse the country to be able to go to different courts, that is something that virtual court really has addressed. Of course, they do it in some hybrid versions for trials, depending. But usually when there's a jury, it tends to be in person. And that's fine, because at least you know what your timing works for and you organize based on that. But the virtual courts we have been able to juggle, I think it's been very helpful for us.
That's good. And what is your vision for the future in terms of the public defenders department? I'm not sure if it's the intent for you to stay there for a long time. But
you want my staff to start picketing?
No, I know one thing I know, they are very, very supportive of you.
I am very lucky.
Yes.
I have great staff.
Yes.
I mean, staff, employees who are like family. I'm very grateful. And, you know, it is a privilege to lead them, I must say that. But in terms of what's the long-term goal, I mean, ultimately, we want to achieve what we were set in place to do. At the time when we were put into place, the idea was to treat with the backlog. And ultimately, we are but one stakeholder, so we can only do so much. But there have been a number of things that have gone into play. The DPP's department, they have gotten some more attorneys. I'm sure they too don't have sufficient, but they've gotten some more attorneys. We have seen a JIPA come into play. We have had more judges that have been employed. We have masters that are supposed to be coming on board, at least to have more masters. So the hope is that we're able to significantly address that backlog. And, you know, I always say with that caveat, we need some more people.
Yes, but of course, the backlog is really more, I mean, and it's just my view, due to the lack of resources on the prosecution side, because the defense can be ready.
Yes and no. I think it's a stakeholder problem. Everyone has to play their part. Everyone has to work effectively, because all the defense counsel, we could be ready, yes, but if we don't have enough courts, if we don't have enough judges, and when I say courts, enough physical spaces, if we don't have enough judges, I mean, it depends, because we know what we're in. Our situation is that there is a significant number of matters. On average, the backlogged matters used to be, give or take, 10 years old. So we need to chip away at that. And I think that is the hope, that we're able to start meaningfully getting more of those matters out of the system. Very
good. And we'll be hearing a jipper. Tell us, of course, persons who may not know or who do not know, what is a jipper?
Well, firstly, it's a, a shortened version.
Yes.
It's a shortened version. So it stands, as we know, for the Administration of Justice Indictable Proceedings Amendment Act. So that is what...
That's a mouthful.
It is a mouthful. So that's why we say a jipper. But what it essentially is, I mean, separate about what the act is, what it really encompasses is the move from what used to be previously the magistrates' courts. So the abolition of preliminary inquiries. So previously at the magistrates' court, now that is called the district court, you would have a matter, all criminal matters would start there. And for indictable matters, which are generally the serious matters, so you're talking sexual offenses, violent offenses, gun, drugs, all of these things would start there. And then the magistrates would determine whether there was sufficient evidence for it to be heard at the high court level. But that time in magistrates' court was not a short time.
Yes.
It was not a short time. It could be a while.
Yes.
So it meant then that you may be in magistrates' court for a matter. Let's say it took 3 to 5 years for your matter to be completed at the magistrates' court. You only had step 1. And then what would happen is that from that, the notes would have to be compiled. The notes will have to be sent to the DPP's office, and then the DPP's office would then have to proffer that same indictment that you would have started the show off with. They would have to proffer, they would have to file that indictment to put it before the High Court. But that process itself, which is the collection of the notes, sending it off, filing the indictment, also took time. So by the time the matter got to the High Court, it was many years later. Yeah. Not as a problem for everybody. It's a problem because it meant that victims were not getting their matters dealt with in any quick time, so they couldn't move on with their lives. Accused persons who are before the court also found themselves having this hanging over their head for a significant amount of time. And then, of course, the public at large, when you want to deter crime, it didn't help. So the idea behind a JIPA is that we abolish it. We move these matters that they are now filed in the High Court, and that we go through what essentially is an evaluation on the papers, and then move the matter to the judge. So that is, as in a nutshell, as I can give you.
Now, we've removed preliminary inquiries from magistrates' court to the High Court. Now, tell us, who hears the... So, is it that there is still a hearing, a mini hearing, prior to determination as to whether it goes before a judge?
So you have an initial hearing, which is when the matter is filed, and that initial hearing is heard before a master. At that initial hearing, they set out a scheduling order.
And can you just explain for the listener's sake, who is a master?
Right, so a master is a judicial officer. They have essentially, they were created by legislation as well. They have essentially all of the same powers that a judge would have, but their role in this particular area is to deal with these matters that are now filed under JIPA. So they determine, so they start the process. So at that initial hearing, the complaint is filed, and it is put before the master. The master is going to give that scheduling order, which is essentially a detailed order giving timelines and deadlines to do particular things, which is usually for the police or the attorney for the police to file all of the documents that they're relying on to make their case. And then they also give an order for the indictment to be filed at the same time. So you have that process happening there. Once those things are done, then we have what we call a sufficiency hearing, which is essentially where the master is going to hear your submissions, if you have any, from the defense, and then evaluate the documents that have been filed and determine whether there is a case to answer. So is there enough material, is there sufficient material that mandates that this matter goes before the judge to move to the next step of actually having a trial? And that is what the process has moved to.
Now, is there, no, but in terms of the timeline, is there a legislative timeline in which a judge, in which a master has to determine these particulars prior to moving to the High Court?
From the date of initial hearing, there are some timelines which the legislation says that you should try to do it in. But the general catch-all is as reasonably soon as possible. Because the reality is we currently have 4 masters that are dealing with all of these matters. I think when we get more masters, it'll be easier to make it a shorter time frame. So the matters can be heard relatively quickly. I mean, at least one matter has already been set down for trial that would have moved off the sufficiency hearing and went before a judge. At least one matter has been set down for trial, and on our end, I can speak to at least 5 to 6 matters that have already been determined to have sufficient evidence and has gone before the judge and is being case managed before the judge. So when you think that a JIPA started on the 12th of December last year, we're not talking years. We're talking months currently. Okay. Now, of course, when it gets before the judge, it has to be case managed, and then we have to set a trial date. And the judges obviously have a docket that they're dealing with. So, I mean, it still has some maneuvering to do. But in the term of that initial going from, you know, the whole process that was taking many years, we've at least shortened that.
Well, one may ask, one may say that, well, it's still months, and therefore it means that the real the evidence that is successful is still to be determined, versus, okay, magistrates court, the magistrates probably would have been doing the same thing as the master, unless, and you can tell us, is there a rule that would have changed in terms of how the magistrate did stuff versus how the masters, the procedure, and how the masters do things?
So at the magistrate's court, you are allowed to call your witnesses to be cross-examined. So a defense counsel could indicate, I want to cross-examine John, you know, Tom, how many other witnesses they wanted. So if you had 10 witnesses, we could ask for all 10, or we could ask for 3. And of course, that prolonged the proceedings a little bit more. Now, it means that when you get to the current situation, which is the sufficiency hearing, it is an adjudication, it's a decision that's made on the documents that are filed. Nobody's being cross-examined, no one is giving live testimony. So no one is going in any box normally. There are exceptions to everything. So there are circumstances where they may need to come. But that is the exception rather than the norm. And for cross-examination, that is not something that's happening at this stage. So that process has changed and significantly reduced the timing.
And now, with the advent of the passing, of the criminal proceeding rules, what year was that criminal proceeding rules? I believe. Was it 2017 or so?
I think it's 2016, 2017.
Somewhere around there. Did that help in terms of ensuring that timelines are met, like as opposed to, well, not as opposed, but in similarity to the civil proceeding rules, where you have basic timelines in which, okay, one has to file a claim, you have 20 days to respond. So I
think the civil process has been around for a little bit longer, and I think in terms of how it works on the civil side, we're working out some kinks on our end still. So I do think in terms of the keeping deadlines, yes, we get directions and we get deadlines, which is not something that we had before. But the keeping of deadlines is contingent on a number of things, because it is not, you see, civil, the parties are within control of their items. So on the civil side, you have all of the documents relative to your disclosure as the attorney dealing with the matter. On the criminal side, the prosecutor does not have the police documents. They are reliant on the police to pull documentation. They are reliant on the Forensic Science Center to perform particular tests. So there are a number of stakeholders in the criminal justice system that we don't all work at the same time necessarily.
Right. So one depends on the other.
One depends on the other. So in terms of keeping those deadlines, I would say sometimes it's not as easily kept because of those peculiarities of how the criminal justice system works, because it's not just one person dealing with a matter, which I think is something that the civil side has it a little easier.
No, of course, a JPOD, does it have a retroactive, does it work retroactively to cases that may would have started in the magistrate's court and it's still before, because if you're saying that the preliminary inquiries have been abolished,
yes.
What happens to matters that are currently before the magistrate's court within previous legislation?
That's an excellent question, because there is a provision within the Act that allows for a magistrate, upon hearing submissions from both sides, to essentially transfer the matter. So matters that have been at the magistrate's court, district court, I'm still getting accustomed to that district court.
Yes.
Matters that would have been previously there, it means now that once both sides are heard, the magistrate has that discretion to move the matter to before the master. So we do have quite a number of transferred matters that are coming in.
And when we say discretion, meaning that a magistrate can decide not to allow a matter to be transferred?
I think yes, absolutely, they can. They can, because, for example, if significant progress had been made in that matter, so, for example, they have almost completed it, they have one more witness to go, that is not the type of matter that they would want to transfer, because for all intents and purposes, it's almost done. But if it's something where they're still at the filing of statement stage, where they haven't actually determined anything yet, or even considered anything significantly yet, that is a better stage for transfer. So it really boils down to the facts of the case and how far along in the proceedings they have reached.
And of course, just to clear the air, with the passage of this particular legislation, now indictable matters transfers directly, well, the first point of your case management is at the master's court.
Correct.
Well, at the high court before
the
master.
Correct. It is filed in the high court, it comes before a master, or it's transferred if deemed to be fit to be transferred, and then we case manage there.
Now, let's look at after the matter has been adjudicated on by the master, it goes before the high court. But prior to going before the high court, is there an election to be heard via jury trial or judge alone trial? I know
not at that time. It happens at when you get before the judge. At that time, you will determine your election. So it's not done at the stage of sufficiency hearing. No, that's not something that's dealt with at that point.
And the type of matters, I mean, I know you explained the type of matters that are indictable. Based on the Act.
It's a long list. It's a long list.
Murder.
Absolutely. Murder, manslaughter, possession of firearm, possession of drugs for trafficking.
Sexual offenses.
Sexual offenses, all of them. You have fraud. So many matters.
No, you mentioned, I know we spoke about a matter that you were quite familiar with, where an indictment was laid for theft or larceny. Larceny. Yeah, in the sum of is it $40 or something?
Well, you know, there's some. The reality is that it was an old matter. So normally those matters, you try to deal with it at the summary level, because some of these matters could be triable either way. So it really boils down to where it was determined. And traditionally in the magistrate's court, they would ask the client, they would ask the accused person, well, where do you want your matter to be heard? Do you want it to be dealt with here, or do you want it to go before a judge and jury? And some people said they wanted it to go before a judge and jury. So sometimes you would have those triable either way matters that would unfortunately make it all the way to before a judge to be treated with.
No, I mean, I know this is a segue, but can you explain the difference? I mean, it may sound obvious to an attorney, but the difference between, or rather the advantages and disadvantages maybe of having or electing to, for a matter to be heard before a jury.
I feel like that you're trying to catch me in a tickle.
versus a judge alone.
I mean, you know, there's a lot of discussion and debate surrounding judge alone and jury trials. Traditionally, we had jury trials. It was only recently that we started doing judge alone. There are, you know, benefits and, you know, disadvantages to both sides, really and truly. In terms of, I'm going to choose my words well. Yeah. Because, I mean, it really boils down to the case. Yeah. If your case turns on a complete legal issue, something that would be so complex, fraud, for example, is not something that you necessarily would want a jury to adjudicate on. You don't necessarily want a jury to be making a decision on something that is going to require you to bring many witnesses to explain how money came from X to Z, you know? Because it sometimes is very challenging for a lay person to understand. Sometimes it's challenging for me. You know, when you think about some of the complex fraud and how you are tracking money, for example. So money laundering is a good example of that. So a situation where it is particularly complex, there is an advantage to a judge being able to deal with that because they may be more able to understand that as compared to the jury who may be easily confused about those key aspects.
But then one may say, one may say, well, the fact that the jury is so confused, they may probably think, okay, it's too complex that they will just say, no, what, not guilty. Or they may use their subjective approach to say, well, I mean, they are complicating things. Why not just,
I mean, of course,
give a not guilty verdict?
But they could also give a guilty verdict.
Yes. Yes.
And that's what you're trying to avoid, because you're trying to avoid a situation where the verdict is not in accordance with the evidence. You are trying to avoid that. So there are certain circumstances, I think, where a judge alone trial may be beneficial. Similarly, there are certain circumstances that a jury trial would, you know, so some things that may happen. So for example, if let's say a murder and it happened during the course of a fight and it was as a result of, let's say, provocation. Something happened and there was a conversation between the two persons. Somebody threw a particular allegation at the next person. That person got angry because of what was said. You and me may not be the persons who get angry in those situations. But to the common man who's standing up by the taxi stand and hearing words getting thrown at each other and knowing what a particular insult may mean, they may react differently and they may understand it differently. So that, you know, the traditional concept of a jury was really to deal with that common sense approach of what the normal person walking down the road experiences and to bring that into the courtroom, separate and apart from the legalese, you know, what we may know as the legal terminology and so forth. That's one part of it. But the ability to assess things based on just general common sense and life experiences, that's where the jury part of it comes in. Now, you know, and that's why I said it's a very touchy subject, yes, because there are arguments on both sides. And it really boils down to, you know, the case, what's the best fit for the case, and then, of course, in some cases, what the legislation prescribes, because there are other jurisdictions where judge alone is mandatory for certain things. So it really boils down to a lot of that. Is
that the case in our jurisdiction?
No, our current position is that it's an election.
Okay. And is it that as a public defender advises their client as well which route to go?
We are obligated to give them. We are obligated to tell them both sides the benefits, the strengths and weaknesses of their case. So it's so much more than, hey, you should just do judge alone or you should do jury. We explain to them, and some people have very firm viewpoints about what they want to do. Some people are adamant they want a judge. Some people are adamant they want a jury, because it's their matter at the end of the day, and ultimately what they want to do with their matter, it's for them. And we're not trying to influence them either way.
And one will ask, how a jury is necessarily selected? I mean, I know it's by the electoral list, but what is the process in terms of jury selection?
Jury selection, it's changed a lot since COVID. But yeah, it is from the electoral list. You're sent your notices and then you show up on the particular day. They have a box and each person is assigned a number, and then you basically, it's the luck of the draw. Yeah. And then once your number is called, we have both sides, the prosecution and defense, have challenges. There are usually 3 challenges per accused person, and then we can challenge for a number of reasons.
What are some of the reasons that
we don't have to, meaning that
you don't like somebody if you look at them?
Internal reasons. Yes. Internal reasons, meaning that we don't have to indicate what those reasons are. So, sometimes it's just, you might see a person who looking real unhappy to be there, and you're like, well, this person not going to be interested in hearing anything. So you may challenge that person.
But it's not mandatory to disclose.
No, so we are not. This is not the U.S.
news
system where you get to ask questions. So all those things you see on TV, that does not happen here.
Yeah.
It does not. But it's a fairly simple process. And if for any reason that a juror does not, cannot participate or has a particular difficulty, there's an exemption process, which they can indicate to the court beforehand. These are my concerns or these are my issues, So there are ways for the jurors to also, alleviate any concerns that they may have.
So back to the administration of justice indictable proceedings. Well, AJIPA.
Let's go with that.
Do you foresee, or is there at this point any setbacks with respect to, I mean, I know we stated the benefits, but in terms of any challenges that are associated or with the implementation of AJIPA?
I think as with any new process, there's teething. There are teething issues. So some of the issues we've encountered is just, so for the transferred matters, the ability to get those documents that have already been filed. That has, been a challenge because a lot of that was done hard copy, and yet it now has to be transferred, scanned and so forth. So that has been, some degree of problematic in relation to that. And I mean, it's just the managing of deadlines as well. As I said, the prosecution has, all of these matters that they are dealing with. We're not necessarily dealing with every defense matter. We're dealing with legally aided matters. But the prosecution's department, they're responsible for all. So sometimes they're just not able to keep up. And so that, delays some issues and so forth. So I think, but all of that boils down to teething and staffing and resources, and I think as those things are worked out, we should be able to move matters along.
Now tell us, how can one access, in terms of, I mean, I know it's for persons who cannot afford counsel on the outside, but how does one access, what is the criteria? In terms of
an application, for legal aid. So
yes.
For criminal matters specifically, there are a couple of ways that you could get legal aid. You can, if you're in custody, you can indicate to the welfare department in the prison that you wish to have legal aid, and they will send your name on to the public defender's department, and we will visit you virtually and process your application. If you're on bail, you could walk into any of the legal aid offices, which is, Stanmore Avenue in Port of Spain, Arima, Chaguanas, San Fernando and Tobago. We have a number of offices. Yeah. So you can go to any of those offices. And
can we pull up those contacts if possible?
So yeah,
legal aid.
Yes. Absolutely. So the general contact number is 638-5222. So you can call, we even have, the ability where you can get advice over the phone, but they will process your Form 9 applications at the offices, that is the form according to the Legal Aid and Advice Act that starts the process. Once, so you can do that. Your family members can make a request on behalf of you as well. You could also indicate to the court when your matter is called that you wish to have a legal aid attorney. an attorney appointed for you because you cannot afford, and the court will direct us to appoint for you.
And that's at your first hearing if
Any
you
hearing.
attend without an attorney?
Any hearing.
Okay.
You could be going for trial next week and then you don't have an attorney. Any hearing, you can actually ask for it. So there are a number of ways to get legal aid and to apply for legal aid. In terms of the authorization process, once you have made an application, wherever your matter is, so if you're in the district court, it will go to the district court for approval and the judicial officer will approve. If you are in the high court, it's going to go to the relevant high court and a judge or a master will approve. So it is not that legal aid approves, the judicial officers approve, and usually it's not that you have to do a means test and so forth. On the civil side, there are those requirements. But for criminal matters, the judicial officer decides whether or not you qualify.
Is there any circumstance where one will be where one will not be afforded the opportunity to?
It's very rare. It's not something that I've seen
attorney?
Because for a criminal matter, in the interest of justice, they will usually grant you an attorney.
And is that is a basic constitutional right to be
able to have the right of representation? Absolutely.
Right. So therefore, some takeaways in terms of what advice that you would give to aspiring attorneys. I mean, I know a lot of attorneys look at the program. A lot of soon-to-be attorneys look at the program, and also women. I mean, I would have asked senior counsel Cho to that question as well. Women in the criminal bar. What advice you can give to these young people, these Gen Zs especially, who seem to be attracted to corporate because money is what is more important now.
Well, money pays the bills, so I appreciate that. So I think, I actually started out under Ms. Choate Senior Counsel. So, Ms. Choate actually was that initiation for me into the criminal justice system and how criminal law worked. And I think one of the things that I learned and I practice is that criminal law is not this field that you have to be fearful of. It is not something that you have to think that you cannot do. Ultimately, if you believe in wanting to assist persons, it's one of the best areas that you can, because there's no shortage of need. And then in terms of being able to do an area of law that is exciting and where advocacy is such a big part of it. So for the young attorneys, you're watching Suits, you're watching Law and Order. Criminal law is where you get a lot of this. This is where you get to speak in front of a jury. This is where you get to really display your advocacy skills. And I think it is a really good area to practice in, because the ability to, think on your feet and so forth, it's something that you have to do in criminal law. So I would just say don't look at it as something that you cannot do or should not do or shy away from. I think even my parents, when I first started, were like, girl, what is happening? That concept of, why you doing that? Yeah. But ultimately, for me, it was service. And doing legal aid and doing criminal law is something that I was always passionate about. And I feel that if you have that passion and you have that drive and you learn to set your boundaries very early with your clients, then you have no problems. Now, I can't promise...
What about the package?
I was not going to say, I can't promise you riches. But I do think that generally, across the board, any attorney coming out, you are not going to be driving the BMWs.
I always have to remind some young attorneys
our
of that.
Expectations of, material benefits that's not something that comes from day one. That is something that you work towards, and that's something that you would work towards in any profession. And even if you decided to do corporate, it is not going to be day one in corporate. So ultimately, I think generally when you are practicing law or practicing anything for that matter, do what you love and do your job well, aspire to be the best, and you will find that all the things that you desire and want come with it.
Indeed, indeed. And in terms of the criteria for an attorney to be employed in the Chief Public Defender's Department, do you need any experience as...
So we have different tiers. So it depends on, so if you're coming in as an entry-level attorney, you don't require any experience. We expect that you would have done an LLB and you have a practicing certificate, which in and of itself means that you would have been exposed to general concepts of criminal law, because that is part of what you would do as in doing your degree and doing your practicing certificate. So we don't expect anything more than what everybody has been exposed to during their schooling, but that's the entry level. As the tiers go up, we have PD1s, we have PD2s. As the tiers go up, of course, experience is required for those tiers. But it's specific, so if you're applying to be a PD1 with us, we expect you to have 2 to 5 years experience. That's the criteria for that particular tier. But generally, you can start with nothing. And that's not necessarily a bad thing to do, because
you have to gain experience somewhere.
Gain experience. And one of the benefits of working at the Public Defender's Department, or just any department, I would say, where you have the ability to have a lot of senior attorneys around you, you have the ability to learn in a group setting, that benefit when you come out as a young practitioner is immense, because you get exposed to a whole lot more than if you just went and put up a shingle and trying to do your work piece by piece. You have so much more exposure when you are in any of these type of departments. And not necessarily limited to criminal law. You have SOLGEN, you have Chief State, you have the DPP's office. You have very many areas where you can go and get exposure, which I think is so important when you come out as a young practitioner.
And in terms of the structure of the Public Defender's Department, you have your chief, you are the Chief Public Defender, and then there are different, is it Public Defenders?
There's a chief, we have the deputy who is second in line, and then we have 9 public defender, 2 seniors. So those are the next senior most persons in the department, and then it goes down from there.
Okay, so it's a lot of, it's quite a big department, and I'm sure it will grow. I'm certain that it will grow tremendously, and maybe this may be the catalyst for persons to want to give service. And also, I mean, I'm sure the Public Defender's Department pays their attorneys well.
We do pay our attorneys.
See, so the numbers in terms of the Public Defender's Department. Josh, you have it on there. Yes, that's a legal aid and advisory authority. So basically, you have all these offices in Port of Spain head office, which is Stanmore Avenue, Arima, in Pennywise building, in Shogunas, San Fernando. Miss Jackson did state that, oh my God, she's so excited to see this episode. She's such a lovely person. Shogunas and Tobago. So those are the contact numbers for legal aid. Of course, you have the Chief Public Defender's Department for persons who wishes to engage the Chief Public Defender's Department, as well as you have the legal aid department. Yes, so your final words. I mean, I know we have discussed a lot. So tell us, what your final words before we close.
I think in terms of me personally, I know you asked me about young women before.
Yes.
And I think it's appropriate to, mention those persons. So Miss Sita Hall, who's no longer with us, Miss Choate, these are female practitioners who have opened the doors for persons like me to achieve, and who have given the direction, the mentorship, and, really set the bar for what female practitioners can do, especially in the criminal arena. And I think that it's important for young attorneys coming out to appreciate that there is the ability to achieve, there is the ability to do. The sky really is the limit. I know that sounds entirely cliche.
Yes, it does, but it still
really
makes
is.
sense.
It really is. I think working hard cannot be discounted. Having a passion for what you do, believing in what you do, and just wanting to make a difference. I think those are all prerequisites to being able to do your job well.
Indeed.
And I think I am encouraged because I do currently tutor at the Hewitting Law School, and I am encouraged by quite a number of attorneys coming out of there, and I think that the future is bright.
Yeah, the future is bright, and you tutor is criminal practice.
Criminal practice and procedure.
And procedure, yes, and a very interesting and exciting topic for many. A lot of law students, they do well during law school, and then when they come out to practice, they just decide, you know what, I'm not doing criminal law, But it's the best place to own your advocacy skill. They always
Absolutely.
indicate that, to be the best advocate, you start off in criminal practice. I mean, I did criminal practice at one point, my first year of practice. I remembered my first bail application. My senior was just like, to represent his client, you know the law. And I literally had to go before, at that time was Magistrate Ramsby Hines, when she's now High Court judge. And I mean, it was exhilarating. Obviously, they know when you are young and fresh and green.
Yes,
and
those bands look very new.
And the judicial officers really try to assist you and guide you as well. So thank you so much, Ms. Sheikh, Senior Counsel.
Thank you for having me.
And all the best in your future role, your future endeavors. And we're all proud. We are all proud. I know your department is very, very supportive of you. And continue doing a great work in the interest of justice and for persons who require that assistance and that representation that is afforded to them.
Absolutely. Thank you so much for having me today.
Thank you so much. So, guys, it has been a wrap. You have been watching Strictly Legal on WESN Content Capital. We had Mrs. Haseen Sheikh, Senior Counsel, Chief Public Defender. And, of course, next week we have another excited guest. But I won't reveal as yet. You just have to wait. So, before we go, I leave you with this quote. Gratitude makes sense of our past. It brings peace for today and creates a vision for tomorrow. By Melody BT. Have a good day. God bless. Enjoy your week.
WESN.
Young at heart, purpose-driven, patriot even. When you like to party, but are still passionate about discussing important issues, the only place where your needs will be met is WESN Content Capital.
We are tackling the hard-hitting topics, some controversial topics, some topics we sweep under the rug. You don't always have to forgive in a relationship for it to move forward.
If it is you are in a situation where you forgive the person, but to the detriment of yourself, what are you really doing?
It is very uncommon for somebody in the younger age group to have dementia.
Atheists don't not believe.
Is that I can't disprove God, but you also can't prove God, so we cannot have a stalemate.
We'll focus on the woman who's being the victim,
right,
or the man is being the victim. We exclude the children.
Folks are trying to study the underlying brain mechanism to figure out how does this particular disorder happen in the brain? How is the brain processing this?
Don't worry about AI, worry about humans working with AI.
Are you willing to learn new skills to stay relevant for the future job market? That's the challenge that people are going to struggle with.